I thought it was for general government, but that's fine. Yes. Good afternoon. Well, Chairman Dolan, I guess had to leave, and members of the Finance Committee. I wish to speak in opposition of a section of House Bill 166, and I'm a board member of the Ohio Community Rights Network. I'm opposed to section 2305.011, which was added as a last-minute amendment just before the Ohio House of Representatives voted on the bill. This amendment is an underhanded attempt to undermine the Lake Erie Bill of Rights, or as we call LEBOR, which was overwhelmingly passed by Toledo voters this past February. In spite of large sums of money, dark money, from BP North America under the guise of Toledo Jobs and Growth Coalition. Section 2305.011 states that, and I'll quote part of it, nature or an ecosystem does not have standing to participate or bring an action in a common pleas court. It prohibits any person on behalf of nature or an ecosystem from bringing or intervening in an action in such court, and it prohibits any person from bringing an action against a person who's acting on behalf of nature or an ecosystem. Since the late 1990s, Lake Erie has been plagued with toxic algae blooms, and almost 5 years ago there was a massive bloom that significantly affected the people of Toledo. It created a crisis so dangerous that they were not able to even touch their water, let alone drink it. Motivated by this, a campaign was formed by a group of Toledo citizens to do something about it after years of neglect from industry and the legislature. Well, at the end of February of this year, the citizens of Toledo overwhelmingly passed the Lake Erie Bill of Rights with 61% of the vote, which granted rights to Lake Erie and its entire ecosystem to exist, flourish, and naturally evolve. This law empowers citizens as part of the larger ecosystem and who have the right to a healthy environment to stand up for the lake when those rights are violated. This is the first of its kind law to grant rights to an entire body of water and its ecosystem in the United States. Similar rights of nature laws have passed in Australia, New Zealand, Ecuador, India, Bolivia, Brazil, and Colombia. This is something that should be celebrated by Ohio, and the Ohio legislature should be leading the way forward in recognizing this. This drew international attention, and some of the grassroots activists responsible for the Lake Erie Bill of Rights were invited to speak at the United Nations on International Mother Earth Day in April of this year. In a time when we are experiencing climate crisis and the rate of extinction of species is accelerating, we can no longer see nature as just property and a resource, but something that has rights itself. This is a paradigm shift that is so desperately needed and represents a way forward for the survival of our planet. We are not separate from nature, we are an integral part of it. If we continually allow nature and ecosystems to be polluted and destroyed, then we are destroying ourselves. The seeds of this idea of rights of nature have been planted long before, but now it's crucial that Ohio and the world fertilize and embrace granting rights to nature. In his visionary dissenting opinion in the 1972 Supreme Court decision, Sierra Club versus Morton, Justice William O. Douglas argued, and I quote, "The critical question of standing would be simplified and also put neatly in focus if we fashioned a federal rule that allowed environmental issues to be litigated before federal agencies or federal courts in the name of the inanimate object about to be despoiled, defaced, or invaded by roads and bulldozers, and where injury is the subject of public outrage." Contemporary public concern for protecting nature's ecological equilibrium should lead to the conferral of standing upon environmental objects to sue for their own preservation. He further added, "The river, for example, is the living symbol of all life it sustains, nourishes, fish, aquatic insects, otters, fisher, deer, elk, bear, and all other animals, including man, who are dependent on it or who enjoy it for its sight, its sound, or its life. The river, as a plaintiff, speaks for the ecological unit of life that is part of it. Those people who have a meaningful relation to that body of water, whether it be a fisherman, a canoeist, a zoologist, or a logger, must be able to speak for the values which the river represents and which are threatened with destruction. Personally, I find it a grave injustice that non-living corporate entities are often granted standing, but the living, breathing people are locked out of the system. I ask, do you? So, I am disgusted that the Ohio House chose a backward path rather than a vision forward on this issue. Also, the process of adding last-minute amendments to a budget bill that have nothing to do with a budget just to get something through for the benefit of big money interest is as slimy as the toxic blue-green algae that the Toledoans are trying to prevent. Therefore, I'm asking the Senate to be more forward-thinking with the budget bill, to be supportive of local democracy, the health of Lake Erie, and all of the Ohio's natural habitats and ecosystems, and all people who depend on them by removing this section from the budget bill. It has no place there and should never have been added in the first place. Unless you want to leave a legacy for future generations as dark as the money that attempts to defeat the will of the people, I ask you please remove section 2305.011 from the budget bill. Thank you.
Thank you for your testimony. Any questions for the witness? See none, thank you for your time.